Hi, I'm Mandy Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer, and today's question is another reach into our legal hotline mailbag. Here's the question. I'm in the middle of a transaction and I am representing the buyer. The appraisal came in $30,000 below purchase price, so the lender for my client submitted a reconsideration back to the appraiser, and during that period I sent the Form 22AN Notice of Low Appraisal along with the initial appraisal to the listing agent. We received the reconsideration back from the appraiser today and they are not changing the appraised value. We haven't received a response from the seller yet on the Form 22AN Notice of Low Appraisal. However, my clients have decided, regardless of whether the seller is willing to reduce the price to the appraised value, buyer wants to terminate the purchase agreement. Do we have to wait for a response from the seller, or can my buyers check the box on the 22AN to terminate and get their earnest money back? If you want to think about the answer or discuss it in your office before you hear my answer, push the pause button. The important part of this answer is understanding that the Form 22AN, the Notice of Low Appraisal, is just that, it's a notice. It's not an addendum to the contract. It's not a request for a modification of the contract. The Notice of Low Appraisal can result in a modification of the contract. Once buyer delivers the Notice of Low Appraisal, it could result in the seller offering or agreeing to lower the purchase price to the appraised value. It could also, however, result in the seller trying to get a different appraisal, or result in the seller rejecting the Notice of Low Appraisal, or offering to meet the buyer somewhere in the middle, maybe take $15,000 off the purchase price. The Notice of Low Appraisal is a notice that the buyer's lender's appraisal came in low. Because it's a notice, there's nothing to withdraw. If it was a request, for example, buyer asked seller to lower the price $15,000, then buyer could withdraw that offer or that request to lower the price of $15,000. It would have, in that context, the offer would have been in the position of seller lower the price $15,000 and I'll proceed with the sale. If you don't lower the price $15,000, then I'll terminate the agreement based on my financing contingency. That would be an offer, and buyer could withdraw that. The 22AN, however, is just a notice. All that buyer's done is let seller know that the appraisal came in low. Now, based on the Form 22A, delivery of the Notice of Low Appraisal triggers an option for the seller to do one of a few things, and seller has 10 days to do one of those things. So if the seller agrees in this case, I shouldn't use the word agrees because, again, buyer hasn't made the request, but if seller came back in this case and said, I will lower the purchase price $30,000 to meet the appraised value, the question is then, what happens? Is buyer then obligated to close the transaction with that reduced purchase price? And the answer to the question is yes, but only if buyer's lender agrees to fund the loan based on seller's reduction of the purchase price. So Form 22A, the financing contingency, says that once buyer delivers that Notice of Low Appraisal, which this buyer has clearly already done, that gives the seller the right to come back for 10 days and agree, among other things, to lower the purchase price. So if our seller does that, buyer is, based on the language of the Form 22A, obligated to close the transaction if buyer's lender agrees to fund the loan. So maybe the easy answer in this case is to say, well, that's simple enough. Buyer will just let buyer's lender know that buyer doesn't want the loan to fund. And then buyer's lender won't fund the loan, buyer uses their financing contingency, terminates the transaction, and they get their money back. But you can't be quite that quick with that answer, because remember that every party to every contract has a duty to perform the terms of the agreement in good faith. And so if seller can prove that buyer thwarted buyer's loan by explaining to buyer's lender that buyer doesn't want lender to fund the loan at the price that seller has already agreed to reduce the purchase price to, then seller would have a very good argument that buyer proceeded in bad faith and put into question whether or not buyer could recover their earnest money or not. Remember, any buyer who's claiming earnest money under the Form 22A financing contingency must get that paragraph 5 lender letter. And the lender letter has to show the date of loan application and that buyer had sufficient funds to close the transaction. And the third issue that lender has to show, and that's the important one in this case, is the reason why buyer's loan wouldn't fund. And if it can be proven by seller that the reason that the loan wouldn't fund is because buyer told the lender buyer didn't really want the loan to fund, that would be evidence of bad faith, and perhaps the financing contingency would not protect buyer after all. So in this situation where buyer has changed their mind and may not want to purchase the property even if the price is reduced $30,000, buyer doesn't have an easy remedy. Perhaps the only thing buyer can do is hope that seller comes back with some other alternative. If seller comes back and says, I'll split it down the middle with you, I'll reduce by $15,000, you bring an extra $15,000 to the closing table, certainly buyer can walk out of the transaction. If the seller came back and rejected the notice of low appraisal, certainly the buyer could walk away. In this case, it seems fairly clear that the seller is not probably going to get an appraisal at purchase price for this lender, or an appraisal acceptable to this lender. So that's probably not even an option on the table. So really buyer's only risk is, will seller lower the price by $30,000? If seller does that, buyer has a good faith obligation to close the transaction, if buyer's lender will fund the loan. If you have questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.